Welcome to the Judicial Committee of the Privy Council, where today we're hearing an appeal from the Court of Appeal of the Cayman Islands in the case of Day and Bush and the Governor of the Cayman Islands. I'm hearing this appeal with four of my colleagues, whom I'll introduce now. Lord Hodge.
Good morning.
Lady Arden.
Good morning.
Lord Sales.
Good morning.
And Dame Victoria Sharp.
Good morning.
The appellants are two women who wish to marry in the Cayman Islands, and the central issue in the appeal is whether they have a right to enter into a marriage there under the Constitution of the Cayman Islands. The appellants are represented by Mr. Edward Fitzgerald, Queen's Counsel. I'll turn now to Mr. Fitzgerald and invite him to begin his submission.
My lords and my ladies, and just by way of introduction, I'm hoping firstly to introduce the present position of the appellants, then to summarise our case by reference to 6 broad propositions, and finally to develop those points and deal with some of the issues raised by the respondents. So if I can start with a few prefatory remarks. As set out in our case, which the court will find at page 697, at the heart of these proceedings is the question of whether two women who have fallen in love, who have committed themselves to one another, and who wish to spend the rest of their lives together, are entitled to have their relationship recognised by the state in the same way as any other couple, namely by marriage. That is what the appellants Chantelle, Day and Vicky Bodden Bush petitioned for in the Grand Court of the Cayman Islands, and that is what the Chief Justice of the Cayman Islands held they are entitled to. In so holding, he found violations of the right to family and private life under Section 9 by the denial of the right to same-sex marriage, a violation of the right to freedom of conscience, contrary to Section 10 of the Caymanian Constitution, and a violation of the prohibition on discriminatory treatment on grounds of sexual orientation, contrary to Section 16 of the Constitution. My lord, you have that in the bundle, the key rulings at paragraph 354 of the Chief Justice's judgment at EB 125 to 126. And so if I could just take you to that very briefly, at 125 to 126, the Chief Justice records the fact that the petitioners have the right to private and family life and are entitled to the state's manifestation of its respect for those rights by the provision of a legal institution which protects those rights. These rights include the right to found a family, which is, if not located within Section 14.1, is then located in Section 9. He found that Section 14.1, the fact that it enshrines the right to marry for opposite sex couples does not mean that the similar right is not located for same-sex couples in Section 9. He found that there was no principle of constitutional construction that allows for the preclusive and discriminatory reading of Section 14.1, for which the respondents contend. And he said that there must be a generous and purposive construction given, and that the approach adopted by the Attorney General was based on the austerity of tabulated legalism rather than the approach commended in cases such as Fisher and Ray's. The fourth point was that by its ongoing refusal to recognise and respect the rights of the petitioners, the state has been and remains in violation of their rights under Section 9 of the Bill of Rights, the right to family and private life. He also found that there was a violation of Section 10 of the Constitution by the denial of same-sex marriage, and because of the reasons for the introduction of Section 2 of the Marriage Act. He found further, and this is at the top of page 126, that the violations of their rights were accompanied by discrimination on grounds of sexual orientation. And finally, he found that there was no justification for the discriminatory treatment on any basis permitted by Section 16 of the Bill of Rights. So that, in very brief summary, is what the Chief Justice found. And in accordance with that judgment, the appellants were due to get married on the 10th of April of 2019. But then on the 9th of April 2019, the Court of Appeal ordered a stay of the Chief Justice's judgment. You see that at EB page 137. And as the board knows, the Court of Appeal later ruled on the 7th of November 2019 that the Constitution did not confer a right to be married on the appellants or any same-sex couples. They found that no right to marry on the part of same-sex couples could be derived from the Constitution. And that was because of the express terms of Section 14(1), which they relied on. I quote, "The government shall respect the right of every unmarried man and woman of marriageable age freely to marry a person of the opposite sex and found a family." The key rulings of the Court of Appeal, my lords and my ladies, are firstly at paragraphs 97 to 98 at EB 167 to 168, and there the board will see at paragraph 97, EB 167, the wording of Section 14(1) on its face defines marriage in terms of marriage between a man and a woman. The wording in our judgment precludes same-sex marriages. It seems to us Ms. Rose was right when she submitted that as a matter of syntax and logic, the words "the right of every unmarried man and woman of marriageable age freely to marry a person of the opposite sex" makes up a single composite expression, meaning in effect have to be given to the words "a person of the opposite sex." If, as Ms. Rose puts it, the framers of the Constitution had intended that same-sex couples should enjoy a constitutional right to marry, the words of the opposite sex would have been odious and misleading. The absence of the word "only" before "of the opposite sex" does not support the proposition that the limitation expressed in these four words can be ignored, circumvented, or expanded. Moreover, as Ms. Rose observed, it is only within Section 14(1) that the words "every man and woman" appear. My lords, my ladies, you may have seen that there's an article which explains, and we say maybe a matter of common sense, that actually the reason for spelling out "every man and every woman" was that it was derived from Article 16 of the Universal Declaration of Human Rights. And the reason why it was spelled out that it was the right of every man and every woman was so that there would not be a paternalistic notion that the right of marriage in 1950 was the right only of men. That's the idea that they were trying to exclude same-sex marriage deliberately in 1950 is frankly ahistorical. And if one goes on from there, there's at paragraph 103 of the ruling, which is at EB 169, the rationale underlying the decisions of the European Court of Human Rights applies equally to the Bill of Rights, just as a right to marry cannot be derived from Articles 8 and 14, because Article 12 is the lex specialis as far as marriage is concerned, so it cannot be derived from Sections 9 and 16, or for that matter, Section 10 and 16. In other words, a specific defined and restricted right to marry under Section 14 cannot be extended by reference to other general rights. So that was their reasoning, and we respond that in fact there is nothing in Article 14 that excludes resort to Article 8 and to Section 8 and Section 9 of the Constitution, and especially Section 16 of the Constitution, to found a right on the part of same-sex couples to marry. And finally, if I can just conclude the summary of the judgment, paragraph 108, one sees that the Court of Appeal say that as we read his judgment, this is at the top of page EB 170, the Chief Justice was influenced in his conclusion that Section 14(1) did not preclude same-sex marriage by his understanding, possibly based on submissions made to him by the appellants below. It was in fact based on the submission made to him by Sir Geoffrey Jowl, that if it did, same-sex marriage could only be introduced by an amendment to the Constitution. That is not so. The Court of Appeal says, as Ms. Rose submitted, the Legislative Assembly could legislate for same-sex marriage. If it did, the resultant right to marry would merely not form part of or be enforceable under the Bill of Rights. And of course, I just make this point. If it is not underpinned by the Constitution, even if the Legislative Assembly introduces marriage for same-sex couples on day A, they can remove it on day B, because there would be no constitutional underpinning for it. So we just make those short points. But as the board will see, the crucial question then arises is whether the Bill of Rights of the Cayman Islands, contained in Section 14(1), a clause that has to be read as excluding the right to marriage, that we say would otherwise certainly be given both by Section 9 and by Section 9 and 16 of the Constitution read together. And we say that the answer is no, it does not expressly or by necessary implication exclude reliance on Section 9, Section 10 and Section 16 of the Constitution. Now, can I just give a little bit more about the situation at present? Though the Court of Appeal didn't uphold the appellant's right to marriage, they granted a declaration to the effect that there had been a long-standing and continuing failure on the part of the government to accord legal protection functionally equivalent to marriage to the appellants. That's at paragraph 117 at EB 171 to 172. Now, the board will know that that declaration was granted on the 7th of November 2019. Once given effect, it would obviously have improved the situation of the appellants and their young child, as described in Chantelle Day's second affidavit. Can I just give you the reference? Because it set out there the difficulties with immigration, the difficulties with the status of their child, and countless other difficulties of formidable nature that they had experienced. That's at pages 251 to 252. If given effect, the declaration would have delivered them from the legal no man's to which they had previously been consigned. But despite that declaration, in November of 2019, there was then further delay. Even after 8 months, the legislature rejected legislation to introduce civil partnership on the 29th of July 2020. And there were, in fact, judicial review proceedings started by Cayman Colours against the governor. Subsequently, the governor introduced a civil partnership law on the 4th of September 2020, which you have in tab 4 of the authorities. And that's very similar to the UK civil partnership law. But that was introduced some 5 years after the decision in Oliari in 2015 had made clear that there was a right to the protection of some form of civil partnership law under Article 8 of the Convention, and therefore necessarily under Section 9 of the Caymanian Constitution. And the necessity to introduce change after the Oliari decision in 2015 had been pointed out by the Cayman Islands Human Rights Commission as early as July 2015. And you have the letter from the chairman of the commission at EB page 260. So that's back in July 2015. And that point was later re-emphasised by the appellant Chantelle in correspondence with the Governor and the Premier dating back to September 2017. You can see that in the electronic bundle at 254 to 256 at paragraphs 6 to 13 of Chantelle further affidavit. So we say that history fully justified the Court of Appeal's finding of, I quote, a long-standing and continuing failure to accord legal protection to the appellant's relationship over a period of some 5 years now. And now, even the government's provision of civil partnership, belated as it was, is itself under challenge. That was the reason for us putting before the board Chantelle further affidavit, dated the 22nd of January 2021, which we invite you to consider at least de bene esse, and we particularly refer to paragraphs 8 to 11 of that affidavit, which is at EB 4663 to 4664. As set out there, permission to judicially review the Governor's introduction of the civil partnership law was granted on the 20th of November 2020. That was not made public at the time, and you've seen that there is a press release of February the 3rd saying that that was by error rather than deliberate decision, though there had been an earlier statement suggesting it was by a deliberate decision. So the grant of permission means that even the provision of a limited civil partnership regime is now itself under legal threat. And I make this point, by contrast, had the Chief Justice's judgment of the 29th of March 2019 remained in force, the appellants would by now have been validly married back in April 2019. And this perhaps indicates why this is not, as the respondents have asserted, a matter that can or should be simply left to the legislature itself. Moreover, if it is simply left to the legislature to introduce the right of same-sex couples to marry without any constitutional underpinning, then what the legislature does today, it could simply undo tomorrow. But, my lords, my ladies, even if civil partnership were firmly established and subject to no challenge, it would not be a satisfactory or just solution to say, you cannot get married, but you should be content with civil partnership. This is not just about labels. It's about the spiritual and emotional reason why a couple such as the two appellants want to be married, and the obvious discrimination in reserving marriage itself for heterosexual couples alone and relegating same-sex couples to the alternative institution of civil partnership and no more. Now, we've set out some of the learning on this point in the written case at 4.9 at EB 708. The South African Constitutional Court, in the case of Fourie in 2005, Justice Sachs stated this, I quote, historically, the concept of separate but equal served as a threadbare cloak for covering distaste or repudiation by those in power of the group subjected to segregation. That was also a truth. You have that at 4.9 EB 708. But that very same truth was appreciated by the US Supreme Court in their judgment in the case of Obergefell. And I give you a quotation from EB 1377. It demeans gays and lesbians to block them out of a central institution of the nation's society. And you have a fuller quote in the written case. And the same point was eloquently made by the Inter-American Court of Human Rights in its advisory opinion 2017, when it stated, I quote, "Moreover, in the court's opinion, there would be no sense in creating an institution that produces the same effects and give rise to the same rights as marriage, but is not called marriage, except to draw attention to same-sex couples by the use of a label that indicates the stigmatizing difference, or that, at the very least, belittles them." The board has that full quotation at pages 709 to 710 of the electronic bundle in the case at 4.11. So we say that those points are of universal truth and emphasize the discriminatory nature of this so-called separate but equal institution. Turning nearer to home, the unlawfulness of discrimination in this context was recognized in the Steinfeld case by the Supreme Court. And you have that ruling at tab 23 in the electronic bundle at 1583, and the final ruling at page 1609. And we've analysed the Steinfeld decision in our case at 8.26 to 8.28, electronic bundle 739 following. There's a clear parallel between the denial of civil partnership to other sex partners that was condemned by the Supreme Court in Steinfeld as discriminatory, and the denial of marriage to same-sex partners that is at issue in this case. And then in addition, there is a judgment of the Northern Ireland Court of Appeal in April 2020 in the case of Close, which you have at volume 8, electronic bundle 3852, at paragraph 58. I will come back to it, but there they found that the denial of marriage to same-sex couples violated the prohibition on discrimination in Article 14 of the European Convention, read in conjunction with Article 8. Now, that was in the context of a consideration of the European Convention, which has the same type of provision in Article 12. And we say that my learned friend submits for the respondents, Close was wrongly decided in that respect, and that they were wrong to say that Article 8, it came within the ambit of Article 8. But we say that that is a telling and correct analysis of the position, and directly analogous with the situation here. And more broadly, we say that such discrimination condemned in Steinfeld, condemned in Close, identified by the US Supreme Court, the South African Constitutional Court, Court of Appeal of Ontario, such discrimination against same-sex couples matters. It's unfair and it undermines the rule of law. My lady Baroness Arden, it's sitting in the Court of Appeal in the case of Steinfeld, quoted these words from Lord Nichols in the Guidon case. I quote, "It goes without saying that Article 14 is an important article of the Convention. Discrimination is an insidious practice. Discriminatory law undermines the rule of law because it is the antithesis of fairness. It brings the law into disrepute. It breeds resentment. It fosters an inequality of outlook, which is demeaning alike to those unfairly benefited and those unfairly prejudiced." And we say that the same values underlie Article 16 of the Caymanian Constitution, which the Chief Justice found to have been violated by the denial of same-sex marriage under Section 2 of the marriage law. Now, if I can then turn to the 6 key propositions that we made. Firstly, first proposition is this, it may be a bit wordy, that the institution of marriage is constantly evolving. the institution of marriage predates the Constitution, and it's not a creature of the Constitution. The Constitution doesn't give the right to marry, recognizes it. And moreover, that right is constantly developing in the Cayman Islands and throughout the world. It has continuously evolved to incorporate couples previously excluded on grounds of religion or race, and the history of exclusion of people from marriage on grounds of religion in the past, grounds of denomination in the past, is set out eloquently in the Chief Justice's judgment at paragraphs 84 to 103. And he there sets out also the prohibition on mixed race marriages and draws the clear analogy with the present exclusion. We say that exclusion from marriage on grounds of sexual orientation is no longer justified. It no longer accords with developments throughout the common law world. That is as a result of, firstly, of constitutional rulings in such landmark cases as the Halpin case in Canada, which you have at volume 1, tab 11, at 1086 following, and we've analysed that in the written case. The case of Furi in South Africa, which you have at volume 2, tab 16, in the electronic bundle at 1224 following, and the case of Obergefell in the United States. And I know you were referred to that in the Ferguson case, and you're familiar with it. So that's first of it. There is an evolving common law tide recognizing that the denial of same-sex marriage violates fundamental constitutional norms. And these norms are not, in our respectful submission, sealed off and compartmentalized such that they exist only in one constitution and don't belong in another. The second point we make is that this evolution is the result of legislative changes in the UK and 15 out of the 20 jurisdictions that make up the UK. Now, the Chief Justice recorded this development, including the development in the overseas territory, in his judgment at paragraph 304, which you can find at EB 110. And he makes the point there at the bottom of EB 110. Sixthly, it is significant that the Cayman Islands is one of only 5 of the 20 distinct jurisdictions of the United Kingdom not to allow for same-sex union, along with the other 4 Caribbean overseas territories, and one of only 6 not to allow same-sex marriage, the Caribbean overseas territories and Northern Ireland. Of course, Northern Ireland has since changed, as is recorded in the closed case. The vast majority of citizens of the United Kingdom may marry in their home jurisdiction, regardless of their sexual orientation. Cayman Islands being an outlier in that regard is significant when assessing whether the cited justification of tradition or public morality is reasonable. So we make that. The next point is we say that this change in the UK and in the jurisdictions that make up the UK. Oh yes, sorry. Can I just refer you also to our case at EB 703, and you'll see in our case at EB 703 we've set out the position in the jurisdictions, including the dependencies, at the very bottom. And you can see all the the overseas territories: Aquaterian, Dekelia, Bermuda at present, British Antarctic, British Indian Ocean Territory, Falkland Islands, Gibraltar, Guernsey, Isle of Man, Jersey. You can see them all set out there. And the position is the 5 that do not expressly allow same-sex couples are Anguilla, BVI, Cayman Islands, Montserrat, and Turks and Caicos. The American court, in its advisory opinion in 2017, has likewise held that there is a right to same-sex marriage guaranteed by the American Convention of Human Rights. And moreover, you have that decision at volume 10, tab 107, pages 4595 to 4596. And I've given you a quotation from them dealing with the point, well, why is not civil partnership enough? And they forcefully say the only purpose of retaining that distinction would be to retain the stigma and the belittling of same-sex couples. And the position is moving at pace throughout all the countries of Western Europe, except Italy. The board can see that position in Western Europe at a glance. If you look at the document at page 314 of the record, you can see there that where it deals with the status of same-sex marriage, and this was a document produced in 2019, and you can see all the countries of Europe: Austria, Belgium, Denmark, Finland, France, Germany, Iceland, Ireland, Luxembourg, Netherlands, Portugal, Norway, Sweden, Spain, United Kingdom, and I think Switzerland just changed. So the worldwide position in the advanced democracies in February 2019 is also summarized in that same document. And that was the position in February 2009. It has even moved on since then. So as the European Court recognized in the Schalken-Kopf case, the position is moving very rapidly. It had moved rapidly already when the Schalken-Kopf decision was given in 2010, but in the last decade, it is increased at pace. So against that background, we say that Section 2 of the marriage law violates Section 9, 10, and 16. And that's our second proposition. The statutory provision in question is Section 2 of the Cayman marriage law, which you can find at 937 in the bundle of authorities. The marriage is now the Marriage Act, but it originally described as the marriage law, and it's at 937. And I know that all will be familiar, but it simply says at the top of page 937, in this law, marriage means the union between a man and a woman as husband and wife. And so that statutory provision excludes same-sex marriage, and it was introduced, as we know, in 2008. We say that this violates Section 9, Section 10, and Section 16. And I will deal with those in detail shortly, but we say it violates the right to respect for private and family life, dignity and autonomy guaranteed by Section 9. It violates the right to equality of treatment guaranteed by Section 16, read in conjunction with Section 9. And it also violates their right to freedom of conscience, which enables them to manifest their belief in marriage guaranteed by Section 10. Were it not for Section 14, we say that on good authorities, there can be no doubt that the appellants could invoke provisions of Section 9 and 16 to secure recognition of their right to be married, and could rely on the ever-growing consensus of the common law decisions, which I briefly referred to. And it's just as obviously discriminatory to deny them, a same-sex couple, the right to marriage, as it was held to be discriminatory to deny opposite-sex couples the right to civil partnership in Steinfeld. It's just as clearly discriminatory to deny same-sex couples in the Cayman Islands access to the institution of marriage, as it was found to be discriminatory in Northern Ireland in the case of Close. And I've given you the reference, but it's para 58 of Close at EB 3852. My lords and my ladies, the third proposition is that section 14 can be restrictively interpreted so as not to frustrate the rights that would otherwise be conferred by section 9, 10 and 16. So what we say is, just, if you imagine a constitution in which section 14 was not there, you could easily and unproblematically derive those rights from section 9, 10 and 16 as interpreted in cases such as Cayman and Close, and as similar norms have been interpreted throughout the common law world. But so we turn to section 14 of the Constitution. That's the section which the government and the Court of Appeal rely on. We say that the words there, government shall respect the right of every man and woman, every unmarried man and woman of marriageable age, freely to marry a person of the opposite sex and found a family, can be reasonably interpreted as going no further than to guarantee the rights of every man and woman to marry a person of opposite sex. The historic right is guaranteed and protected from being removed. But that guarantee of marriage to that particular class does not exclude the right of others to access the institution of marriage on the basis of section 9 and 16 and also 10 and 16. Section 14.1 does not expressly say so. It doesn't say, as the Chief Justice pointed out, doesn't say only every unmarried man and woman of marriageable age, it shall respect the rights only of every unmarried. It simply says it shall respect right. And that guarantee of marriage to some, we say, doesn't expressly take away rights that can be derived from section 9, 10 and 16 for same-sex couples. It doesn't do so by necessary implication. And the question is not what was the historical intention at the time, which is what the Court of Appeal confined itself to. We don't think that was the intention at the time. It's the question of what can those words reasonably be read to mean to give effect to the general principles of constitutional interpretation, that there should be a broad and purposive approach that gives effect to rights rather than taking away rights. And so read, it would, of course, prevent the abolition of the institution of marriage for couples of different sex. You couldn't just say, we're going to only have civil partnerships. Marriage is defunct, as some people have advocated. It would ensure that you couldn't burden the institution by different sex couples by excessive costs, restrictions, or that would violate section 14. So it can be given a meaning, but the meaning that can be given to it is to respect the right of the historic different sex couple to be married, rather than to exclude, by reference to other sections, the right of same-sex couples to access the same institution without discrimination. And so that's the basic third proposition. And our fourth proposition is that the principles of constitutional interpretation developed by the board support such a restrictive interpretation of section 14. There are two sides to the basic principle of constitutional interpretation. Firstly, that the provisions guaranteeing fundamental constitutional rights, such as 9, 10 and 16, must be given a broad and generous interpretation to, I quote, to ensure contemporary protection of those rights in the light of evolving standards of decency that mark the progress of a maturing society. That's the quotation in the case at 6.12, EB 722, from Lord Bingham in the Rays case. And we've cited it in our case. The relevant paragraph of the Rays decision is paragraph 26 at 1529 to 1530. And that gives effect to the dynamic interpretation, the living tree doctrine, that the words of the Constitution must be given a broad and generous interpretation, such as permits the evolution of concepts in keeping with evolving standards of decency. And the other side of that is a principle that any provision that purports to restrict rights should be narrowly construed. And we deal with that in the case, in the written case, at pages 723, 724, and we rely on the decision in the case of Hughes. The relevant paragraph is paragraph 35, where Lord Rogers is saying, wherever there is a restrictive provision in a constitution, in that case the savings clause, nothing in section 5 shall invalidate a law that authorizes a description of punishment that obtained at the time of independence. I'm paraphrasing it, but that had been interpreted to mean you simply couldn't attack the death penalty for the mandatory death penalty for murder. It had been so interpreted in the Pratt and Morgan case, and Lord Rogers was saying a restrictive interpretation must be adopted to anything that purports to restrict fundamental right. And so we say that there's a fundamental objection to interpreting section 14.1 as restricting the right to access the institution of marriage that could otherwise be derived from section 9 and 16 read together, or section 10 and 16 read together. And therefore we say it would be contrary to basic principles to treat section 14.1 as a provision exclusively regulating all access to marriage and as excluding access to marriage by any individual or group not mentioned in section 14.1. By reason of its express wording, section 14.1 simply couldn't address or meet the aspirations and rights of same-sex couples in relation to either marriage or founding a family. It says freely to marry and found a family. Well, in order to give a right to same-sex couples to found a family, you have to look outside section 14. You have to look to section 9. So some of the substantive rights, which plainly on any view would have to exist, have to be located outside section 14.1. The right of same-sex couples to found a family by way of adoption. The Court of Appeal and my learned friend accept they have to have a right to found a family, but they say, well, you can get that from section 9. And we say precisely, not everything is catered for in section 14.1. You have to look outside section 14.1 and look to other provisions of the Constitution to locate the rights of a same-sex couple to access that institution and to found a family. And so we just make one further point. I will come to the European Court case, but can I just summarize in advance? In the Schalken-Kopp case, the European Court recognized that Article 12 which is similarly worded, except it doesn't have the words of opposite sex, which you find at page 859, would come in time to yield the right of same-sex couples to marry. In other words, there wasn't anything in the wording of Article 12 of the European Convention which foreclosed for all time the reading into it of the right of a man and a woman of opposite sex to be married. And so there you can understand why the European Court said, well, because Article 12 could in time develop to recognize a right to marriage on the part of same-sex couples, you should look to Article 12 and only Article 12 for that right. It's the only means by which it could be asserted. But that's not the case here because of the words of opposite sex. Clearly, there couldn't come a time where one could found the right to marry on the part of same-sex couples on Section 14. And therefore, you do have to look outside Section 14 for the right to marry, which international norms and international practice increasingly recognize is a right that should be given to same-sex couples if there is not to be discrimination on grounds of sexual orientation. And could I then turn, this is my fifth proposition, that the European Court's jurisprudence is a floor and not a ceiling. And can I just summarize the position of the European Court in its jurisprudence? Firstly, the position, and it's really three stages, the position at present is that the European Court has recognized that Article 8 applies to guarantee the right of same-sex couples to enjoy family life for the purposes of Article 8. Can I take you to Schalk? That's at volume 2, tab 22, and it's paragraph 94, which is electronic manual 575. So 57. So this is Schalk. So sorry, I think I may have got the right. The electronic bundle. It must be 1575. I'm so sorry. 1575. And so if we look at 1575 of Schalk, they set out the increasing recognition of same-sex couples as having the same right to the recognition of their relationships as opposite-sex couples, and they conclude at paragraph 94, electronic bundle 1575, paragraph 94, in view of this evolution, the court considers it artificial to maintain the view that in contrast to a different sex couple, a same-sex couple cannot enjoy family life for the purposes of Article 8. Consequently, the relationship of the applicants, a cohabiting same-sex couple living in a stable de facto partnership, falls within the notion of family life, just as the relationship of a different sex couple, the same situation would. So that's that it falls within the definition of family life at 94. And then...
Can I just interrupt, Mr. Fitzgerald? It's notable that there the court is basing its conclusion on a rapid evolution of social attitudes in many member states. Now, one can't simply take it for granted that the same change has taken place in, for example, the Cayman Islands. The board has made this point before in, that one can't automatically translate judgments of the European Court to the the context of the jurisdictions that the board deals with. If the culture and attitudes are significantly different.
Well, my lord, I would say that this is a universal norm. It's recognised in the Inter-American Court's decisions, which, after all, are in the very region which your lordship is referring to. It's recognised throughout the United Kingdom overseas territories other than in the Caribbean. And one asks on what rational basis the Cayman Islands, an offshore paradise, if I can call it that, should be treated differently. But my lord, certainly the Inter-American Court is dealing with the very region that we're concerned with. These are, in our respectful submission, universal norms. But my lord,
you can hardly say that. I mean, we're talking about norms that historically are a very recent introduction or acceptance.
Well, I'm so sorry, my lord. The norm of non-discrimination is a universal norm. And so once one's come to the recognition that the same-sex couple has the same right to family life, and that's not disputed, then in our respectful submission, to move from there to saying they have the same right to family life, and they also have the same right to marry, is, in our respectful submission, a very small step indeed. There's no dispute in this case that same-sex couples have the same right to family life. Indeed, if they didn't have the same right to family life, then there would not have been the need, which the Court of Appeal recognised, for there to be civil partnerships. Then the question is, can one justify the denial of marriage once one acknowledges the right to civil partnership? And the only basis is the basis identified as impermissible in the US Supreme Court, again in the same region, in the Inter-American Court, again in the same region, and also in the decision of the South African Constitutional Court, which relates to a similarly racially diverse community. So, my lord, I acknowledge that I think it was your lordship's observation in the case I'm thinking of about life without parole, where you said we don't have to follow we do not have to follow every twist and turn of the European Court. No, we don't. But we do, in our respectful submission, where there's international law binding the upholding of the basic norms of the European Court. We do, in my respectful submission, have to recognise the underlying norms. My lord, I recognise that things have moved swiftly, but we respectfully submit that once you acknowledge that there's a right to civil partnership, that there's a right to family life, what, apart from maintaining the stigmatizing distinction between marriage and civil partnership, is there left? And so, my lord, I hope that begins to answer your lordship's question.
Well, the answer is also, I don't know if that's meant to be a rhetorical question, but there are all sorts of reasons apart from sheer prejudice which could explain why some people take the view that marriage is an institution for people of different sexes. I mean, religion, for one, is a major factor.
Well,
or simply traditional social attitudes, which may be longer lasting in some cultures than in others.
Well, my lord, as to religion, obviously this is a secular state and a secular constitution, and I wouldn't respectfully accept that religious reasons could justify the maintenance of that distinction. As to social attitudes, once it's recognised that civil partnership it's only if it's said that this is a relationship which is immoral or unlawful, and we've gone away from that really for 20 years since the Order in Council removing the illegality of same-sex intimacy. So I would respectfully submit that that wouldn't be a good reason for retaining the distinction. My Lord, I hope I can. Sorry, my Lord, Lord Sales. Yes.
Yes. Well, it was just on that point. If you go to page 848 of the electronic bundle, at the start of the Bill of Rights, section 1(2)(a) says this part of the Constitution recognises the distinct history, culture, Christian values and socioeconomic framework of the Cayman Islands. So whilst it may, in some senses, be a secular society, the Bill of Rights has been drafted specifically with recognition of its distinct history, culture, and Christian values. So well, that rather seemed to me to, if I may say so, support what my Lord Reid was putting to you about the relevance of distinct social traditions, specifically with reference to the Cayman Islands. I wonder what you had to say about that.
Well, my Lord, the first thing I'd say is that the same preamble talks about a country committed to the democratic values of human dignity, equality, and freedom. So it's balanced by those values, which are values essential to any multicultural society. Secondly, there is authority as to the limited value one can attribute to a preamble. I think we dealt with this in some detail in our skeleton argument for the Court of Appeal. And thirdly, I respectfully submit that it would not be proper to say that it's legitimate to maintain the distinction between marriage and civil partnership on a religious basis. That would not be a legitimate objective under the Constitution. And the Chief Justice, who is, after all, perhaps the best guide of the values within the Caymanian Constitution, rejected the justification of discrimination of this nature on grounds of public morality. Said it was not a legitimate aim. My Lord, those are the points I'd respectfully make. I don't also accept, great respect, that Christianity speaks with a unanimous voice in its condemnation of same-sex marriage. I just simply don't accept that that's a proper religious point of view, or sorry, universal religious point of view in any event.
Yes, and just to be clear,
I need to decide.
Sorry?
Happily, that's an issue we don't need to decide.
No, but I mean, we recall what the Pope said. But my lords and my ladies, I just put that caveat there that the assumption that there is some readily readable continuity religious continuity that justifies the exclusion of marriage from same-sex couples, I challenge, and I also respectfully submit that it's not right to say that discrimination follows from the preamble, given that the preamble is also committed to human dignity, equality, and freedom, which are the very underlying norms identified in the cases of Thuri, in the cases of Obergefell, and by the Inter-American Commission. I'm so sorry. My Lord, I appreciate these are profound issues, and I will need to address them further. But I do say that the reasoning of the Chief Justice, which addressed all these issues and found that there was no legitimate justification for the discrimination, is an eloquent and local voice on these very issues. My Lords, can I just conclude the European Court's position, because of course my learned friend puts great emphasis on that. But secondly, the court has further held in the Oliari case that the right of same-sex couples to enjoy family life recognised in Schalk extends to the right to a specific legal framework providing for the recognition and protection of their same-sex unions. And the third point I'd make is that the European Court has not yet recognised the right of same-sex couples to marry. I accept that. The relevant rulings are first in Schalk at tab 22. If I can take you to EB 1569. So, if one goes to EB 1569, paras 61 to 63, paragraph 61, regard being had to Article 9 of the Charter, therefore, the Court would no longer consider that the right to marry enshrined in Article 12 must in all circumstances be limited to marriage between two persons of the opposite sex. Consequently, it cannot be said that Article 12 is inapplicable to the applicant's complaint. However, as matters stand, the question whether or not to allow same-sex marriage is left to regulation by the national law of the contracting state. In that connection, the Court observes that marriage has been deep-rooted social and cultural connotations which may differ largely from one society to another. And then the Court reiterates that it must not rush to substitute its own judgment in place of that of the national authorities, who are best placed to assess and respond to the needs of society. Now, that's clearly a reference to the margin of appreciation back in 2010, and saying that Article 12 is not inimical to the reading in of a right to marry on the part of same-sex couples, but it's not for the Court, because of the need to give margin of appreciation to national authorities, to rush to that conclusion. What else can it be but the margin of appreciation, which of course doesn't apply and didn't apply when the Chief Justice applied his own norms, the norms of the society in which he's the Chief Justice, to this issue. And at paragraph 63 in conclusion, the Court finds that Article 12 of the Convention does not impose an obligation on the respondent government to grant a same-sex couple the applicant's access to marriage. So that's the position in 2010. Can I just refer on?
Well, just before we, Mr. Fitzgerald, just before we leave that passage, I'm rather doubtful myself that it is a reference to the margin of appreciation as such. Is it? Isn't it the Court saying that it should be slow in this context to adopt an evaluative interpretation of Article 12 because of the dangers of it imposing its values under the guise of interpretation on these societies which have deep-rooted social and cultural connotations attaching to marriage of their own?
Well, I'd respectfully submit that if one looks at it, they're saying that the words of Article 12 do not necessarily exclude the right of same-sex couples to marry. So that's it in paragraph 61. And then they say it mustn't rush, i.e. it's a question of timing. It may be necessary to allow time. It's substituting its judgment for that of the national authorities. So that's recognizing this is an area where the national authorities have, in our respectful submission, a margin of appreciation. And what I think it may be, one can get some assistance from looking onwards from there to paragraph 105, electronic bundle 1576, where it says the Court cannot but note that there is an emerging European consensus towards legal recognition of same-sex couples. Moreover, this tendency has developed rapidly over the past decade. We'd say it's increased much more over the decades since 2010, in the last 11 years. Nevertheless, there is not yet a majority of states providing for legal recognition of same-sex couples. But we now know that in Western Europe itself, there is a majority. The area in question must therefore still be regarded as one of evolving rights with no established consensus. I think it's been described by one of the critics in the Hamalainen case. It was the accountants of a majoritarian consensus, the critic that, as it were, how many countries have done it so far. But we do respectfully submit that they're recognizing that the norms are evolving rapidly in 2010. And of course, they've moved on even more rapidly and exponentially in the last 10 years. So my respectful submission is that it is the margin of appreciation that held the European Court back at paragraph 61 to 63 and has still, and I accept it in subsequent cases, such as Oliari and Hamalainen and Orlandi. But that was a position in 2010, and I accept that that is still the position under the European Convention. But our respectful point is that the European Convention constitutes a floor, not a ceiling. That is set out in our written case at paragraph 4.4, electronic bundle, page 706, where we cite the case of Rodriguez, and where Baroness Hale recognised that the Gibraltar Constitution should not give less than the European Court. So that is important, but it should not give less than the European Court, the Constitution, but it could give more. And we respectfully submit that certainly the Caymanian Constitution cannot give less than the European Convention, because otherwise it would bring the UK into conflict with its international obligations under the European Convention. Well, perhaps that is a distinction between the independent sovereign states, such as Trinidad, which was, I think, the case that gave rise to my Lord's remarks about not following every twist and turn of the European Convention. And this, which is subject to, it's part of the United Kingdom in international law, and therefore subject.
Well, is that right? First of all, it's actually Lord Hughes's judgment in a case called Lendor.
Yes, my lord. It is.
I don't know. I rather wonder whether your treatment of the British Overseas Territories and the Crown Dependencies as part of the United Kingdom is strictly correct.
Well, as a matter of international law, in our respectful submission, that is correct, and indeed reflected in the judgment of the Chief Justice. But in any event, it is accepted in the Rodriguez case by Baroness Hale that the Constitution can give no less than the European Convention, though it can give more. My lords, can we look?
I'm not sure it's really what her ladyship meant, but a more possible. It strikes me as rather an extraordinary proposition to say that the Constitution of wherever you like in the Caribbean or in the British Overseas Territories or the Crown Dependencies has as a flaw the ECHR, which is a treaty which doesn't even apply to these places.
Well, my lord, it is binding. the European Convention is binding.
Well, the United Kingdom has undertaken an obligation
Yes.
in relation to these territories.
And so have the Dutch and so have the French in relation to their own.
The reason for your argument, the basis of your argument is that it's because, well, as I understand it, what Lady Hale is saying, that because the what's an issue in, for example, Gibraltar, is not the ECHR, that therefore the ULA principle is not applicable.
One sees in paragraph 11 at page 1548, these provisions do not enjoy the clarity and simplicity of the equivalent provisions of the ECHR. No doubt there are very good reasons for thinking this, but there are at least two good reasons for thinking that they're intended to provide at least a similar level of protection as is provided under the ECHR. The first is that the United Kingdom extended the protection of the ECHR to Gibraltar, so that it would be surprising if Gibraltarians were to enjoy a lesser level of protection for their fundamental rights under this constitution that they do under the ECHR. We say exactly the same applies, with exactly the same reasoning. The UK has extended the protection of the ECHR to the Cayman Islands. So, my lord, that's our response. That it would be surprising, in the words of Baroness Hale, if there were any less protection. But then she makes the point that in fact there can be more, and indeed we say that because the margin of appreciation doesn't apply, that is also so here. And can I just give you the reference in Steinfeld at tab 23 at paragraph 29, and that's I think at EB 1601. The recognition there that the Steinfeld 1601 by Lord Kerr, that it, at paragraph 29, it follows that a national court must confront the interference of a convention right and decide whether the justification claimed for it has been made out. It cannot avoid that obligation by reference to a margin of appreciation. We say that the same approach applies here. And in any event, there are clear distinctions between the wording of Article 12 of the European Convention and the wording of Section 4 of the Caymanian Constitution.
Mr. Fitzgerald, sorry, I just wanted to check on what the formal technical position is in relation to the Cayman Islands. We saw from the passage in Rodriguez that there was an extension of the ECHR to Gibraltar by a formal declaration. I think it's under Article 56 of the ECHR that a state does that. I just wanted to check, has such a declaration been made in relation to the Cayman Islands, and what was the date of it?
My lord, it has been, and my lord, can you just give me a moment to find that? But in other words, a citizen of the Cayman Islands could apply to the European Court of Human Rights. I see my learned friend may be coming to my assistance.
I think I can assist my learned friend. You'll see that this matter's dealt with at paragraph 11 of the respondent's case. It's page 762, and the details are set out at footnote 12 to paragraph 11 of the respondent's case. I should say my learned friend is correct that the European Convention was extended to the Cayman Islands, and in fact there is a right of individual petition to the European Court of Human Rights from the Cayman Islands.
Yes, thank you very much.
So my lords, we respectfully submit, therefore, that the precise same ratio in Rodriguez does apply, that it is at least a floor, and it need not be a ceiling, for the reason that there is no margin of appreciation when you're interpreting a domestic constitution, on which see Steinfeld, para 29. Electronic bundle 601, and I'm grateful to my learned friend for giving me the exact reference. I knew that you could petition. My lord, is that a convenient moment?
Can I just stop for a moment and just think about this?
Yes.
Are we talking about the ECHR applying to Cayman at the level of international law?
Yes.
But it's not been implemented in the domestic law of the Cayman Islands.
There's no Human Rights Act. There is the Constitution, my lord.
Yeah.
So
we, sitting as a court, sitting as the board, as the final court of appeal for the Cayman Islands, are not cannot apply the ECHR as part of its domestic law.
No, my lord, but you can apply the Constitution, which we respectfully submit gives you direct power to interpret the same norms, and we say that the Caymanian Constitution, in some respects, goes further. But it certainly doesn't go. We do submit that you have to interpret, so far as possible, the provisions of the Constitution so as to comply with international legal obligations. That's set out in Matadine and Pointu and in Brind, obviously, so that the Constitution would have to be interpreted so far as possible to give effect to the obligations of the UK under international law.
But Mr. Fitzgerald, have I understood correctly? There isn't actually any incompatibility between the Caymanian Constitution, including Section 14, if it's read in the way the Court of Appeal read it, and the European Convention on Human Rights, because Schalks has said that there isn't a right to same-sex marriage under the European Convention on Human Rights.
My lord, I accept that, and that's why I say it's a floor but not a ceiling.
Right, but if that is the case, then do we get any help at all in interpreting the Caymanian Constitution from the European Convention on Human Rights or the jurisprudence of the European Convention, European Court?
Well, yes, because firstly, the European Convention recognises the language of Article 8 is replicated in Section 9 of the Constitution. The European Convention case law recognises that the relationships of a same-sex couple is protected by Article 8, and we say, by analogy, the relationship of a same-sex couple is protected by Section 9. The question then is what the extent of that protection is, and we say that the extent of that protection, when you're interpreting the Constitution itself, extends to guarantee the right to marry of a same-sex couple. And in reaching that conclusion, the court can have regard not just to the limited approach of the European Court, but also to the decisions of other common law jurisdictions, which I've referred you to: the South African case, the United States case, the Inter-American Advisory Opinion. All those can illuminate the norm that we're appealing to.
Yes, thank you very much.
I don't know, is that an appropriate moment to break or cease hostilities for a moment?
Well, if that suits you, Mr. Fitzgerald, then that's a suitable moment for us. We'll adjourn then for 5 minutes. Thank you very much.
Thank you.
I think we're all ready to resume. Mr. Fitzgerald.
Thank you, my lord. Well, my lord, I did refer to the fact that we had dealt with the question of the preamble in our skeleton in the Court of Appeal. Could I just give the court the reference? It's in the electronic bundle, paragraphs 602 to 603. And we made the point there that the at 4.1 that the preamble, though it refers to a God-fearing country based on traditional Christian values, also refers, as the Chief Justice did, to the mutual respect for all individuals, their basic rights and democratic values of human dignity, equality and freedom. Again, over the page, we make the point that dignity and equality, which are stressed in the preamble, were the very norms that were invoked in Obergefell by the US Supreme Court and in Furi by the Constitutional Court of South Africa. And we also make the point from Larimore at Roman 4 that references to God in the preamble cannot be read upon cannot be relied on to limit or qualify the freedoms guaranteed. And also the Orozco case, the case in which the Belize Chief Justice struck down the laws criminalising homosexual intimacy, made a similar remark where a similar reliance was placed on Christian values in the preamble of the Belize Constitution. I do pray and aid that the preamble, one, it's a limited aid to construction. Two, the reference to Christian values is balanced by reference to dignity, equality, and those very norms were the norms that led to the conclusion that same-sex marriage should be guaranteed in the regional judgment of Obergefell and in the judgment in the Furi case. My lords, my ladies, the sixth proposition, can I just summarize it like this, is that section 16.1 and section 16.7 read together support the case for same-sex marriage. And section 16.1, which you have at 862, subject to subsections 3, 4 and 5, government shall not treat any person in a discriminatory manner in respect of the rights under this part of this constitution, of the constitution. So the once a substantive right such as section 9 or section 10 is engaged, or one's within the ambit of that right, then the government shall not treat the person in a discriminatory manner in respect of that right. So that's the first point, and that's strictly analogous to the European Convention provisions, which were being interpreted in close. And then one sees at subsection 7, subsection 1 is without prejudice to any restrictions on the rights and freedoms guaranteed by section 9, 10, 11, 12 or 14. So recognizing that you can make restrictions on those rights under section 9, 10, 11, 12 or 14, if that restriction would, in accordance with that section, i.e. section 9, 10, 11, 12, 13 or 14, be a restriction authorized for the purpose of that section on the grounds that A, the provision is reasonably required in the interests of a matter specified in that section, or B, the provision and the restriction imposed under it are reasonably justifiable in a democratic society. Now, we respectfully submit, this is our, as it were, fallback position or our alternative submission, that Article 16.1, which we say can just be applied in conjunction with section 9 in any event. But there is a recognition there that if you have a restriction authorized under one of the other sections, including section 14, which deals with marriage, it still has to be tested to see whether it is reasonably required under that section. So that would be under section 14, but also B, whether it's reasonably justifiable in a democratic society. So if you take section 2 of the Marriage Act, section 2 of the Marriage Act is a restriction insofar as it defines marriage for heterosexual couples only for the purposes of section 14. It is consonant with subsection 7a because it's reasonably required for the purpose specified in that section, i.e. is authorized by that section, but you still have to test it as to whether it is reasonably justifiable in a democratic society. Now, the Chief Justice conducted the exercise under 16(3) and concluded that there was no reasonable justification for the discrimination in this case, and it must follow that there was no reasonable justification under subsection 7b. So that is the submission that we make, that it follows from his reasoning that there was no legitimate justification under 16(3), but there would also be no reasonable justification in a democratic society under section 16(7)(b). That's our further and alternative submission. So if I can just try to summarize how we put the case. We say firstly that one can restrictively interpret section 14 itself in such a way that it leaves it open to the court, as the Chief Justice did, to rely on other sections in the case of a same-sex marriage, to rely on the right to family life and private life under section 9, and the right taken in conjunction with that not to be discriminated against under section 16, and to come to the same conclusion as he did, that the exclusion of same-sex couples from marriage violates the rights under section 9 and violates the rights under section 9 read in conjunction with section 16. So, my lords and my ladies, that is our submission. That's our first submission. Our second submission is that in any event, section 16(1) read in conjunction section 16(7)(b) enables the court to say this restriction may be justified under section 14 because of the wording of section 14, but it is nonetheless a restriction which is discriminatory and violates section 16 read in conjunction with section 9 or section 10. My lords, my lady, those are the two ways we put the point, and we've dealt with the argument under section 16(7) in our reply at some length. Can I just give you that reference to where it's set out in the reply? It's the argument based on section 16(7) is set out in our, just if you'll just give me one moment, in our reply at part 4, EB 819 to 823. My ladies, those are the 6 basic propositions. Can I now just expand some of them in a little bit more detail? The institution of marriage itself, we respectfully submit, is, as the Chief Justice found, a secular institution controlled by the state. And we referred the court to the Chief Justice's analysis at paragraphs 84 to 103 of his judgment. It became a secular institution during the 19th century, controlled not on a religious basis, but by the state itself. That institution has been continually evolving since then, and disadvantaged status groups have been historically denied the right to marry on grounds of race and religion, and females have been historically subordinated to males. But the Chief Justice drew this conclusion. Can I give you? It's at page 35 of the record, EB 35, paragraph 101. He said, one might rationally conclude that the legal history certainly does not preclude further development of the law to reflect an evolving view of marriage by reference to the Constitution itself, and that the concept of marriage in the Cayman Islands, I quote, may not be regarded as immutable for all times in deference to a particular religious view. My lords, my ladies, I do pray that in aid, because that's the Chief Justice of the Cayman Islands drawing on the history of the evolution of the secular institution of marriage in the Cayman Islands, getting rid of the old denominational exclusions of Catholics, for example, from marriage, getting rid of the prohibition of mixed race marriages. And he says that the concept of marriage in the Cayman Islands, I quote, may not be regarded as immutable for all times in deference, and I stress this, to a particular religious view. And I do stress that there's no uniformity of religious approach in relation to this matter. And at part 3.6 of the written case, which you'll find at page 703 of the electronic bundle, we've gone on to trace the development throughout the common law world beyond to remedy the historic exclusion of same-sex couples from the institution of marriage, so that there is now a growing consensus in the Western democratic world that such exclusion can no longer be justified, and that it no longer accords with, I quote, evolving standards of decency. You have, I've taken you already to electronic bundle 703. My lord, to the point, well, that may be so in Western Europe. It may be so in America. It may be so in large sections of Central America and South America. But the Caribbean is somehow has its own distinctive traditions which must be respected. My respectful answer to that is you have the voice of the Chief Justice of the Cayman Islands on this very issue, and he assesses whether it is reasonably justified on grounds of public morality, includes it is not. And he assesses whether it's proportionate, includes it is not. And as it were, it's the Court of Appeal that interferes on the grounds of interpretation, but they don't say he's wrong on grounds of his findings of justification. They simply say that you can't go there because of the wording section 14, and indeed my learned friend says you can't go there because of the wording of section 14, rather than because these norms, which have been recognized throughout the Americas, are somehow no-go norms in the Caribbean, which I make the further point that other European jurisdictions, France and Netherlands, have extended, and that appears from the rights to their overseas territories. You can see in that at page 703 that there is the recognition St. Martin's have partially permitted same-sex marriages, and so too Aruba, I think is referred to in the analysis at page 703. So that is my attempt, and to the point that my lord put to me about the Lendor case, as I understand it, that case was really about the approach of the European Court to the question of life without parole, and the particular series of criteria that had been developed in relation to that in the European Court, and that though Lord Hughes held that the basic principles should apply, the basic fundamental norms should apply, he said that not every aspect of the European Court's norms should be applied. But that's, in our respectful submission, very different from something as fundamental as this. Now, and where we, in fact, what we're invoking is not the European Court's jurisprudence, but that of the Inter-American Court, the US Supreme Court, South African Court, and indeed the judgment in the Northern Ireland case of Close. So, my lords, my lady, the approach to the Bill of Rights, it obviously has close parallels to the European Convention. There's clear authority that such a Bill of Rights should be interpreted as, I quote, intended to provide at least a similar level of protection. That's Rodriguez at paragraph 11. And to do otherwise would cause the UK to be in breach of its international law obligations under the European Convention. That we've dealt with that in the case at 6.16 EB 724. But we say the margin of appreciation type of considerations do not apply, because the court would be determining for itself what norms should apply in the Cayman Islands. As to Section 9, which we rely on, that guarantees right to respect for private family life. It's clearly established that the right to family and private life extends to same-sex couples. I've taken the court to the references in Schalk and Kolf at paragraph 94, and in Oliari at paragraph 164, where it was recognised that the right to family and private life extends to same-sex couples. And for that reason, the question of a right to marriage comes within the ambit, we respectfully submit, of Section 9. And that is important when it comes to marriage, to reading Section 9 in conjunction with Section 16. Neither in Schalk nor in Oliari does the court doubt that the issue of marriage comes within the scope of Section 9. They simply say it's more appropriate to analyse it through Article 12, and the reason that they give for that is that it's the more specific rather than the more general right. So they don't say there's no overlap. They simply say that if we haven't got there under Article 12 yet, and we could one day get there under Article 12, then it would be inappropriate to get there under Article 8, even read in conjunction with Article 14. I hope that so there is in our respectful submission a distinction. In the European Court case law, they're saying Article 12 could one day yield the right to same-sex marriage. Not yet, but there is an evolution taking place. In the Caymanian constitution, because of the addition of the words of opposite sex, Section 14 could never yield that right. And therefore, in our respectful submission, one has to look outside Section 14 to accommodate the evolving rights of same-sex couples, including their right to marry. And that actually means that it isn't the lex specialis for same-sex couples, because it doesn't address the right of same-sex couples to marry at all. It simply doesn't address their situation. And therefore, one can develop that right through Section 9 and Section 16 read together, or Section 10 and Section 16 read together. As we set out in our case, Section 9, like Article 8, protects human dignity and autonomy. My Lord Reid, in the Christian Institute case, stressed the importance under Article 8 of the rights of human dignity and autonomy. That's in volume 10, tab 69, and we quote that in our written case at electronic bundle page 710. But it was also recognised by the European Court itself in Goodwin. That's the case of the right of a biological male who'd have gender reassignment to be married to another male. In Goodwin, that's at EB 1075. And there the court said, I quote, "The very essence of the convention is respect for human dignity and human freedom." And they went on under Article 8 in particular, the notion of personal autonomy is an important principle underlying the interpretation of its guarantees. So that was a reliance on Article 8 as applying to guarantee the rights of human dignity and human freedom. Now, it's those very concepts which were invoked in the cases of Halpern, Bury, and Obergefell, the concepts of human dignity and personal autonomy. If I could just give the court those references, because we do invite the court to say that in interpreting Section 9 of the Caymanian Constitution, one can have regard to the fact that human dignity has been invoked in those common law jurisdictions as yielding a right to same-sex marriage. In the Halpern decision, which the board has tab 11, tab 11 from pages 1086 onwards, the Court of Appeal of Ontario held that the existing common law definition of marriage was invalid and needed to be reformulated so as not to exclude same-sex couples from the institution of marriage. It did so on the basis of the principles of equality before the law enshrined in Section 15.1 of the Canadian Charter, which you've got at EB 1112, and on the basis of human dignity, which is referred to at EB 1117. Can I just give you the key passages we rely on? At page 1096 of the electronic bundle, the court concedes that there's a reference to sections 2A and section 15.1 of the Canadian Charter. 15.1 is the equality provision. And it says that this appeal raises significant constitutional issues that require serious legal analysis. And the question was, did the common law definition of marriage as defined in Hyde and Hyde, was it inconsistent with the Charter by excluding same-sex couples? And you can see at paragraph 10 that there is a reference to human dignity at page 1098. And I'm so sorry, if you can see, yes, you can, sorry, paragraph 8 at page 1098, you can see the reference to human dignity as a crucial concept. You can see that further at paragraph 108 at electronic bundle 1127. And there again, the concept of human dignity is evoked. Based on the foregoing analysis, it is our view that the dignity of persons in same-sex relationships is violated by the exclusion of same-sex couples from the institution of marriage. Accordingly, we conclude that the common law definition of marriage as the voluntary union for life of one man and one woman, the exclusion of all others, violates section 15(1) of the Charter. So it's both the concept of human dignity and the concept of equality that are appealed to. And you can see the disposition of the case at paragraph 155, and that is paragraph 155 at EB 1140. We have concluded the following: the existing common law definition of marriage is the voluntary union for life of one man and one woman. The courts have jurisdiction to alter the common law definition of marriage. Resort to constitutional amendment procedure is not required. The existing common law does not infringe his right of religious rights, but it does infringe equality rights on the basis of sexual orientation. And in coming to that conclusion, they had regard to both the right to equality and the right. If we turn to the Obergefell, you have an analysis of that in the case at paragraph 4.17. That's in the electronic bundle, pages 711 to 712. And we rely on the analysis in the case. Essentially, the court is referred to the passage in Obergefell where it was recognized that the due process clause included a right to, I quote, individual dignity and autonomy, including intimate choices that define personal identity and beliefs. And so the Obergefell decision was founded both on the right, on the due process clause and the right to equal protection in the 14th Amendment. And the court majority concluded, this is at EB 1382, these considerations lead to the conclusion that the right to marry is a fundamental right inherent in the liberty of the person and under the due process and equal protection clauses of the 14th Amendment. Couples of the same sex may not be deprived of that right and that liberty. So again, looking at concepts of individual dignity and autonomy, which are the very concepts that underlie Article 8 of the European Convention, Section 9 of the Caymanian Constitution, the US Supreme Court held that the exclusion of same-sex couples from marriage violated individual dignity and autonomy, as well as equal protection. And again, the Furey decision, we've analysed that in the electronic bundle 712 at paragraphs 4.19 of our case. In that case, Justice Sachs noted the overlapping rights violated by the exclusion of same-sex couples from the institution of marriage. And he held that the right to privacy was included. And he said the way the words dignity, equality and privacy, this is at electronic bundle page 1252, the way that words dignity, equality and privacy later came to be interpreted by this court showed that they in fact turned out to be central to the way in which the exclusion of same-sex couples from marriage came to be evaluated. If I take you to the electronic bundle at pages 1295, 1296, 16, so 1295 to 1296, you can see the approach adopted there by Justice Sachs. And yes, in his conclusion, paragraph 114, I conclude that the failure of the common law and the Marriage Act to provide the means whereby same-sex couples can enjoy the same status, entitlement and responsibilities according to heterosexual couples through marriage constitutes an unjustifiable violation of their right to equal protection under Section 9(1) and not to be discriminated against unfairly in terms of Section 9(3). Furthermore, and for the reasons given in the Home Affairs, such failure represents an unjustifiable violation of their right to dignity in terms of Section 10 of the Constitution. As this court said in that matter, the rights of dignity and equality are closely related. The exclusion to which same-sex couples are subjected manifestly affects their dignity as members of society. And I've already shown the board the further observations in Fury about why it's not good enough to simply provide a separate but equal civil partnership jurisdiction. Now, the Chief Justice, and again we've set this out in the written case, in the analysis of Section 9, he in his judgment relied on those decisions of the US Supreme Court and the Constitutional Court of South Africa in his finding that Section 9 of the Bill of Rights was violated as a standalone right. You have that in the Chief Justice's judgment at page 83 of the record, where he, drawing on those cases, concludes at paragraph 3, page 83 of the electronic bundle, and while neither of these courts expressly found a violation of those particular rights, already having made their determination on the grounds of the right to freedom from discrimination or the right to equality of treatment, the fact that those rights, that's the human dignity and autonomy, the equivalent to Section 9 of the Bill of Rights, were violated, is implicit in their respective judgments. And indeed, from the judgment it can be seen that multiple overlapping rights are engaged by the state's exclusion from the important societal institution of marriage on the basis of identity, sexual orientation. These rights, I emphasize for the sake of clarity, include the rights to private life and family life, premised on fundamental notions of human dignity, equality and freedom. And then he goes on to cite Fury and Obergefell, and he then refers to the right to found a family, which is at 227. The right to found a family is also undeniably involved, whether regarded as conjunctive right with the right to marry, recognised by Section 14.1, or as an essential and necessary implication of the Section 9 rights to respect for private and family life. And he then makes the point that there are two rights in Section 14.1, the right to marry and to found a family. What we respectfully submit is we agree with my learned friend and with the Court of Appeal that the right is conjunctive right to marry and found a family in Section 14.1. But what we say is it would be ludicrous to suggest that same-sex couples do not have the right to found a family under the Constitution. They definitely do. If it's not given by Section 14.1, it has to be given, as the Court of Appeal accepted, by Section 9. And that shows that you have to go outside Section 14.1 to do justice to substantive rights, which undoubtedly have to be recognised. You have to go to Section 9.1. They have a right to found a family by adoption, to found a family by surrogacy. They have that right. But it's not located in Section 14.1. It's located, as the Court of Appeal itself found, in Section 9. Now, if that's the case, it shows that for some of the essential rights of the same-sex couple, you have to look outside Section 14.1 to Section 9 and Section 16, right to private and family life and the right not to be discriminated. So, my lords, my ladies, I hope that point is clear, even if it's not yet accepted. We do say that that is an important part of why you can't say Section 14 says everything that has to be said about the rights of same-sex couples to marry and found a family, and they have no such rights. On the contrary, they do have such rights, but they come from Section 9 and Section 16, and possibly from Section 10 also, Section 16. Now, in our written case, we've also dealt with the freedom of conscience provisions that section 10. It isn't the principal emphasis of our case, but we've set it out in the written case in the electronic bundle at pages 713 to 714. And can I just summarize our position in this way? We say that there is clear evidence before the court that was accepted by the Chief Justice that the appellants, Chantelle Day and Vicky Bodden-Bush, have a belief in the institution of marriage. It's attested to by Chantelle Day in her affidavit at paragraphs 28 to 30 in the electronic bundle at page 238. Now, the Chief Justice expressly found that there was a violation of the appellant's right to freedom of conscience by the denial of same-sex marriage. He made that finding at paragraph 122 of his judgment at page 43. And there's one is led to the conclusion that absent some overriding provision, a measure aimed at constraining the otherwise lawful exercise of the right to manifest their belief in the institution of marriage cannot be upheld. So he says a measure aimed at constraining the otherwise lawful exercise of the right of same-sex couples to manifest their belief in the institution of marriage cannot be upheld. So it's basically his finding there is of a violation of the right under section 10 because the violation of their right to express their belief in the institution of marriage. There is, in addition, a finding about the religious purpose of section 2, and I know that the board has dealt with this issue in the Ferguson case. So can I take this briefly? The Chief Justice also found that the 2008 amendment to the marriage law, with the aim of precluding same-sex couples from the institution of marriage for the purpose of promoting a particular religious and traditional view of marriage, was impermissible. That finding was based on his factual analysis at paragraphs 18 to 29, and that's at EB 14 to 16. So you can see that he sets out the background to the 2008 amendment law in EB pages 14 onwards, and he sets out the various remarks that were made, mounting concern in Cayman over the choices made by some other countries and states in the area of sexuality. Prime Minister, there may have been and continue to be concerns within these shores that somehow a marriage officer may be asked, requested, required to carry out a ceremony between persons of the same sex. And then he then said that he believed that it would come, but he hoped not too soon, in paragraph 21. And then one has various remarks made which emphasize religion, and one sees that at paragraph 24, he says further statements in support of the bill, that's to say the Marriage Act, also place strident emphasis on religion and morality, and the reference to the Honourable Alderman McLaughlin, homosexuality is not the only wrong in the world. And then the Honourable Anthony Eden at paragraph 27, referring to this sentiment that the amendment was also necessary to protect the local culture from the influence of people who come to our shores as visitors, was also expressed by other speakers. My lords, my lady, I won't go through all the references. There were invocations of Sodom and Gomorrah and many other Old Testament invocations during the course of that debate. But the Chief Justice, who knows the society, who studied the evidence of those debates, reached the conclusion that there was a violation. He reached the conclusion, first of all, that it was based on the desire to promote a particular religious traditional view of marriage above all others, and that that was impermissible. And so we would say that that is a second strand. The first strand is the violation of the freedom of conscience. The second strand is the fact that it was based on a religious purpose. But obviously I realise that the board has heard argument on this second strand, the religious purpose point. In the case of Ferguson, I simply say that we invite you to consider this further point in the light of the decision in Ferguson. But we say that on both those bases, the ban on same-sex marriage in Section 2 violates the freedom of conscience clause in Section 10 of the Constitution. My lords, my lady, turning then to Section 16 of the Constitution, which we've analysed in the case at paragraphs 4.6 to 4.13 at EB 707 to 710, and again in relation to the Kaidan case, we've analysed that further at pages 739 of the electronic bundle to 743. We do submit that the Chief Justice made an express judicial finding that the exclusion of same-sex couples from all access to the institution of marriage by the terms of Section 2 of the marriage law constituted discrimination on grounds of sexual orientation, contrary to Section 16. He posed the issue at paragraphs 244, and he made his finding of discrimination on grounds of sexual orientation, paragraph 354. You can find paragraph 244 at EB 89. I can just take you to that. Electronic bundle 89. Paragraph 244. He set out the test that there must be differential treatment on one or more ground of discrimination which prohibited, and there's no doubt that other status includes sexual orientation, and that he made a finding that there was discrimination on grounds of sexual orientation. Secondly, Section 16 is engaged only in conjunction with the enjoyment of another right, so he correctly directed himself in relation to that, that it's got to be within the ambit of another right. The Court of Appeal got it wrong there and said you had to find a violation of another right, which is incorrect. The Chief Justice got it completely correct. It has to be in the context or the ambit of another right. And thirdly, it must be shown that the respondent's asserted justification is not reasonable or is disproportionate. So he asked the correct question and he answers that question at paragraph 354 after going through a very detailed analysis, which he concludes that it's not justified on grounds of public morality, and you have that at paragraph, not a legitimate aim, at paragraphs 294, EB 106, and that traditional Caymanian heritage is not in the closed list of legitimate aims. My lords, while we're on that and we're on Caribbean Maoris, the prohibition of the criminalisation of same-sex intimacy was also held to be unconstitutional in the Trinidadian High Court, and the judge in that court rejected the notion that one could appeal to cultural notions to justify that criminalisation. And so one sees that he concludes that public morality is not a ground at 296 at EB 107. He then looks at whether it's objective and reasonable, and he makes the point at paragraph 301, EB 108. Thirdly, and in any event, the history of state-controlled marriage considered above evidence there's no such thing as traditional marriage. He makes the point at 302, fourthly, the corollary of promoting the traditional family, whatever that means, is the discouragement of homosexual relationships. This cannot be an objective or reasonable aim, whether phrased in terms of public morality or otherwise. The means are not rationally connected with a legitimate aim. And he cites there from Rodriguez, where they're saying that that cannot be the discouragement of homosexual sex, cannot be a proper justification. And I do invite the board to follow the reasoning set out at EB 109 there. One sees that he says public morality at 303, evoking traditional public morality, are really pursuing a particular religious or moral purpose, then their justification cannot be either objective or reasonable. And then he makes the point about the majority of the jurisdictions that compose the United Kingdom as a matter of international law. And yes, he draws attention to the judgment in the case, the Jones case in Trinidad, where the judge in the High Court in Trinidad made the point that there's no such thing as a traditional family in a country of multicultural diversity of the region. Single parent families are becoming a norm, which is unsettling of many traditionalists despite its reality. The fact that homosexual relationship is no longer to be regarded as unlawful, and he makes the point that the appeals to traditional values are nebulous and do not provide a proper justification for denying same-sex marriage. And then he finds that there's no proportionality, and in doing that he draws on the reasoning of the South African court and on the reasoning of the Obergefell decision, and help in paragraph pages 113, 114, 115, and 116. Now, I know it's said, oh well, they're slightly different, those constitutions. They have a freestanding equality provision, but we are appealing, as the Chief Justice was appealing, to international norms as to what is acceptable discrimination. And if, as we submit, Section 9 is engaged, or the issue falls within the ambit of Section 9, then the discrimination issue has to be confronted. My learned friend's argument is, well, Section 9 is not engaged, it doesn't come within the ambit of Section 9. And Section 10 is not engaged, it doesn't come within the ambit of Section 10. But if it is, as we submit, within the ambit of Section 9, then one has to conduct the discrimination tests which were conducted by the Chief Justice, as the Supreme Court did in the Caiden and Stansfield case, and as the Northern Ireland Court of Appeal did in the Close case. And if that exercise is conducted, we say that the Chief Justice's reasoning is impeccable and detailed and based on an intimate knowledge both of the reasons put forward and of their lack of substance. And this is not the imposition of some alien norm. This is a universal principle of fairness and non-discrimination, shared throughout the common law courts and applied by this Chief Justice in his home court based on knowledge of Caymanian society. So we do respectfully submit that that Section 16 is violated, and that the reasoning of the Chief Justice is to be followed. The appellant's case on discrimination, you have it set out in the electronic bundle at pages 707 to 710. The Court of Appeal, as I've indicated, they wrongly stated, this is at paragraph 28 of their judgment, paragraph 8.23, that there had to be another right violated. They referred to the fact that I'd made such a concession. I don't recall making any such concession, and if I did, it was wrong. And it's accepted by my learned friend that the test is whether it comes within the ambit. And it's sufficient. Well, you can see the arguments from our skeleton before the court. But the test is, does the issue of on which discrimination is complained of come within the ambit of another convention right? And we say that in Schalk it was recognised that the family and private life of same-sex couples does engage Article 8. We say therefore it engages Section 9, which is in identical terms. And in Oliari, paragraph 103, EB 1482, it was made clear that the issue of same-sex couples' family life comes within the ambit of Section 9. Now, in none of those cases was it said, but family life may do, but marriage doesn't come within the ambit of Article 8. On the contrary, what the European Court said was, because Article 12, which deals with marriage, is more specific, you can't get to a right to marriage via Article 8, and if you get there, it will be via Article 12. That's not saying it's not within the ambit. It's just saying that the time may come, but if it does come, it will be under Article 12. And so we respectfully submit that there is no doubt that the question of same-sex marriage comes within the ambit of Section 9, as it does come within the ambit of Article 8 of the European Convention. And if you just look at Volume 8, the close case, which I've referred to just very briefly, Volume 8, tab 91. So this is the case where the Northern Ireland Court of Appeal held that it was discriminatory not to accord the right of same-sex marriage to same-sex couples, and you can see that they were fully aware of the lex specialis point, which they refer to. If you look at paragraph 41 at EB 3845, they set out there, but they set out the Schalk principle. But if you go to paragraph 47, edit from the bundle 3849, it is common case that the circumstances fall within the ambit of Articles 8 and 12, and it is apparent that access to marriage and same-sex marriage in Northern Ireland is based on sexual orientation. So there, it's common case. Now, my learned friend says, well, they made a mistake, and it was only on the basis of a concession. But you'll see that the distinguished components of that court were Lord Chief Justice, Lord Justice, now Lord Stevens, and Lord Justice Treacy. We respectfully submit they're entirely right to both record the concession and to act upon it. That the right of same-sex marriage comes within the ambit of Article 8 and 12. Now, then they applied the question, has there been a difference of treatment? And they say that there is a difference at paragraph 48, EB 3849. There is a difference of treatment and it requires justification. They say we do not accept it, just above that, submissions about that because marriage and civil partnership offer the same core rights, there is no difference between them. And I've already addressed you as to how in every jurisdiction it's recognised that there is a significant distinction between the two that requires justification. In the Inter-American Court, the US Court, the South African Constitutional Court, and here the Northern Ireland Court of Appeal. They then ask the question, is it justified, just as the Chief Justice asked it in this case, from paragraphs 49 onwards. They refer to the question of cultural tradition from paragraph 51 onwards, and they conclude, they do refer to the fact that things have moved on and been developing at paragraphs 53 and then at 55, where they say it's considerable significance that things have changed in Scotland and Ireland. And at the last sentence of paragraph 55, in our view, the events of 2015 and their consequences increasingly called into question the balance between the interests of those favouring tradition and the interests of those denied the opportunity to be seen as equal and no longer separate. And they conclude that at paragraph 58, we are satisfied that it was clear that by the time of the delivery of the first instance judgment in this case in August 2017, the absence of same-sex marriage in this jurisdiction discriminated against same-sex couples, that a fair balance between tradition and personal rights had not been struck, and that therefore the discrimination was not justified. Now, we respectfully submit that the Northern Ireland Court of Appeal judgment is helpful in indicating, firstly, that the issue of same-sex marriage does come within the ambit of Article 8, and hence we say within the ambit of Section 9 in the Cayman Islands. Secondly, they conducted the question of whether this difference in treatment could be justified and concluded that it couldn't from August 2017 onwards. The Chief Justice sitting in the Cayman Islands conducted precisely the same exercise and came to the same conclusion. And so far as we can see, there's been no argument put in to suggest that his assessment of whether it was reasonably justifiable was wrong. All that they've said is, well, look at the negotiation process 11 years ago. Well, you can't.
What do you say the legal basis is of the decision? I'm having some difficulty following the reasoning.
Oh, well, the first stage is they ask themselves the question, my lord, at paragraph 47, is it within the ambit? And they say it's conceded that it is, so that Article 8 is engaged. And then they ask themselves the question whether the denial of same-sex marriage at a time when civil partnership has been conceded is discriminatory, and they conclude it is. In reaching that conclusion, they're influenced by the fact that there's been a referendum in the south of in the Republic, which has concluded that same-sex marriage should be allowed, and there's been developments in Scotland, as it were. I suppose they're looking at, as it were, comparative geographical positions, and they then reach the conclusion that there is that this comes within the ambit of Article 8, that it is difference of treatment between that requires justification, and that it's not justified. But what we invite the court to do is, just as the Chief Justice did, and just as the Supreme Court did in Steinfeld, is to go through precisely that exercise. The Chief Justice did too. The first question, sorry.
I mean, paragraph 41, which is back on 3845.
Yes.
They say 5 lines down that Article 8 can't supply what Article 12, the lex specialis, doesn't. But they seem to, it rather looks as though they think that Article 8, taken together with Article 14, can.
Yeah. My lord, that's right. That's absolutely right. They're saying you can't do it on Article 8 alone at paragraph 41, but they're saying from paragraph 47 onwards that you can do it on the basis of Article 8 read in conjunction with Article 14, the non-discrimination.
They somehow seem to think that the lex specialis doctrine applies to Article 12 vis-a-vis Article 8, but not seemingly to Article 12 vis-a-vis Article 8 together with Article 14.
Yes, my lord, yes.
Right.
Yeah, and my lord, we submit that you basically, one has to, if one asks oneself this question, what situation are we addressing? The situation is one of the exclusion of same-sex couples from an important state institution, that of marriage. Does that issue engage Article 8 or Section 9? Answer yes, as it was answered paragraph 47. Does it result in a difference of treatment? Yes. Is that difference of treatment justified? The Northern Ireland Court of Appeal came to the conclusion that it wasn't from 2017 onwards. The Chief Justice in the Cayman Islands reached the conclusion that it wasn't justified. And we say no good reason has been put forward to doubt his conclusion on reasonable justification. So my learned friend's argument is not that he got it wrong on reasonable justification, but that he got it wrong that Section 9 was, that it was within the ambit of Section 9. We respectfully submit he got it absolutely right. And that therefore, we pray enable that reasoning. Now, of course, Steinfeld and Cayden, which we've analysed in detail in the case at 739 to 7 EB 739 to 744, goes through a similar exercise in relation to the exclusion of heterosexual couples from the institution of civil partnership. And it's concluded that it does engage Article 8 and Article 14, that it does then require, and this is at paragraph 41 of Steinfeld and Cayden, justification. And then Lord Kerr concludes that this is at EB 1604, that it's not a legitimate aim. There is no rational collection. He deals with the question of whether less intrusive means were possible. And he finally deals with whether a fair balance has been struck between their rights and the interests of the community. And he reaches the conclusion paragraph 52, electronic bundle 1609, that the preclusion of different sex couples from civil partnerships was incompatible with Article 14. So we do rely on Steinfeld, we rely on Close.
Of course, Steinfeld is a case where there's no problem of lex specialis.
I accept. My lord, I accept that because civil partnership is not. Yes, I accept that one. But we do say that the process is analogous once you've got over that problem.
Yeah.
My lord. Don't know whether that would be an appropriate moment, my lord.
Yes, thank you very much, Mr. Fitzgerald. We'll adjourn and resume at 2 o'clock.